Hello and welcome to URM's webinar on data privacy impact assessments and data transfer risk assessments. We will refer to that as DPIAs and DTRAs or DTAs as we go along, so I don't keep tripping myself up on those. My name's Lisa Dargan and I'm joined by Pauline Brace, who I will introduce you to in a moment. Before we dive too far into the agenda, let me just cover a few housekeeping points if I can. There is going to be a feedback form at the end, so please do complete the feedback form if you would like a copy of the slides or equally a copy of the recording. If you do have any questions, please ask. We will try and answer them as we go along if we get the opportunity or at the end. And if we aren't able to answer your questions, then we will forward an answer to you afterwards or contact you to follow up on your question. So just having a quick look at the agenda, we've got a lot to cover today. So we are going to go through in a fairly light touch way. But first of all, data protection impact assessments or DPIAs. We're going to look at the when and who, what the triggers are as to why you would do one, what the process is. I think really importantly for today, what are the common failings? We're then going to move to data transfer impact assessments, DTIAs. Again, the when, the how, the who do you do that? The process you need to follow. We're going to talk about the best tools. There are a number of tools out there, and the supervisory authority guidance that's available to support you with that. In particular, as it seems that the US is a common location for data to be either transferred to or hosted in, and we'll pick that up. We're going to look at EU to US data transfers and comment briefly on the data privacy framework. So let me just give you a bit of background. For those of you that aren't familiar with URM, we have been providing data protection advice, consultancy and training for well over 15 years. We've supported over 50 organisations to achieve compliance to the GDPR, that's both UK and EU. And the really important thing for us, if we've got a passionate team of people who've worked on both sides of the fence, so sitting where a number of you may well be as potentially DPOs or internal data protection resources, as well as consultants. And on the subject of knowledgeable and passionate, I'm really delighted to introduce you to Pauline Brace. Hello, Pauline.
Hi, everybody.
Hi. So Pauline has worked in data protection since 1998. Is very passionate and knowledgeable on the subject, as well as being a senior URM consultant. Pauline's also a certified practitioner and trainer, and can talk comfortably and confidently on UK GDPR, EU GDPR and global privacy legislation. So most of the time Pauline spends working with clients, so we're very fortunate that Pauline's given us some time today to go through data DPIAs and DTIAs. So thank you, Pauline. Good morning and welcome, and let's dive in. So before we get into too much detail, to make sure we're all on the same page, what is a DPIA, please, Pauline?
Okay, despite the myth, it is an assessment of the likelihood and severity of impact on the rights of individuals, not about the rights and risks of your organisation. It's about the individuals, and we need to make sure we focus on that in the context.
Okay, and is it a documented thing, Pauline, or is it?
Yes,
you know?
Yes, it's mandatory in some cases in the legislation, and it must be documented. The reason it needs to be documented is that data controllers, that's your organisations, have an obligation under the legislation to have evidential proof. If you don't document one of these assessments, you will not remember the decisions you made when and why in 2 years' time. You need that documented evidence of having completed it and how you made your decisions.
Thank you. And before we dive in, can I just ask you one more question? Because I get asked this a lot and I get quite thrown by this. When people talk about DPIAs, they then talk about a balancing test.